right, so we are going to get started, and this is a topic that I am seeing happen more and more, and it's the sale contingency. This is not something that we see a whole lot when the market is booming, when there are more buyers and we know what to do with, but it is something that comes up quite frequently when that starts to change, and so let me see if I can share this. We'll try a little bit different format today. So what is being evaluated? The sale contingency. So again, this is something that comes up when your house maybe is on the market a minute, when you've got buyers who have the leverage to negotiate additional contingencies. Dad, during the boom of COVID, we saw deals where they were removing all contingencies, right? No inspections and no financing, all cash.
Yep.
So this is kind of the opposite of that. This is, we're asking for a lot of extra protections. And what are we protecting? We're protecting the deposit. That is essentially what a contingency is we're protecting the deposit. We want to make sure that if something happens that affects the buyer negatively, that they can potentially get out of the deal, that they could get out and save their deposit, get it back. So some of the contingencies we see on a regular basis number one would be the inspection contingency. So you've got two different kinds. You've got your as-is inspection contingency and your standard repair contingency. So in that scenario, on a standard repair contingency, the buyer could get their deposit back only if they found a defect in the property and the seller refused to fix it. So that's our most common contingency there. The as-is obviously is a free look. You don't even need a good reason. You can just, I always say, if you woke up on the wrong side of the bed, you can cancel and get your money back. The other one that we see on, half of the deals out there is the condo review period. So, we have, as sellers, we have a duty to disclose the condo documents to a buyer. The buyer has 3 business days from the time they received it to potentially get out because of the condo docs. Now that's it's interesting, Dad, we see that obviously on every condo sale, but sometimes they're terminating because of some other reason. And that's okay, right?
It's absolutely okay. I encourage buyers during that 3-day period to contact the management company and check out a whole variety of issues, such as future special assessments, insurance claims, any damage from Ian, and just frankly, what the social functions they might have at that condo. Will they like it there?
Yep, exactly. And so that's that contingency. The next one that we see on every deal, or not every deal, but a lot of deals, is a financing contingency. So you'll notice on contracts, you've got cash offer with the right to get financing or more mortgage financing, or maybe it's a mortgage financing contingency. So it might be subject to an appraisal, subject to borrower credit, debt to income ratios. In fact, Dad, on a recent deal that I had, the buyer, this is kind of an example as to how confusing these contingencies can be. The buyer submitted a termination with a loan denial letter, but the loan denial said that they terminated because of, I don't even know if they gave a reason. They may not have given a reason. And the buyer's like, all right, I want my money back. And I said, well, let's get the seller to sign the release. And then they were like, well, why do we need to wait? Why can't you just give me my money back? And the more we kind of, sorted out the deal, the buyer was really terminating because they wanted to make it a primary mortgage, and instead it was going to be a second home mortgage, which means it was going to cost them a little extra. And so they're like, well, that wasn't the deal, and we want out. This was supposed to be a primary mortgage. And unfortunately for them, the contingency didn't protect them that much. It just basically said only if you get denied for a conventional loan could you potentially get your money back. And in this case, the buyer wasn't denied for a conventional loan. They could still get a conventional loan. It's just it would be a second home conventional mortgage. So that took a lot of
paragraph
convincing.
4 is very limiting. I mean, it limits denial reasons for things that affect the credit of the buyer or things that affect the property. And in fact, it calls for a letter of adverse determination from the lender, which specifies the reason. And
It does. It requires it. In fact, I got a little pushback on that because they're saying, nowhere do I need to explain why I got denied for the loan. And I said, well, it's not that simple. Yeah, you do. You absolutely do.
Paragraph 4 requires it. You get situations where people don't submit all their tax returns.
Yeah.
They deliberately sabotage the property. So it has to be something that fits within the confines of paragraph 4, and it has to be that particular form that's called for in the paragraph.
So you make a perfect transition for me. The buyer who might be self-sabotaging the deal in order to get out of it, to get their deposit back. And that's the main concern that I have about sale contingencies. So we're going to look at some of the pros and cons of this. We'll do that first. So pro of a sale contingency protects the buyer's deposit. In this case, in the event they don't sell their other property, the buyer could terminate this purchase and get their deposit back. It also clarifies how the buyer will be paying for the property. So it's pretty clear to everybody that, look, we're planning on selling the home so that we can then buy this home. And it gives the seller the right to terminate eventually. So ultimately, in the event the buyer doesn't waive the contingency and we're not closed, then the seller can terminate and the buyer would get the deposit back. And that's the downside, is even if the seller has the right to terminate, the buyer gets their money back. So the seller receives zero if it doesn't close. That is kind of the main con, and we're going to talk about that in depth. It's also hard to get backup offers, and that's something people don't appreciate enough. So MLS rules, and I have kind of a very basic understanding of MLS rules, but basically once you take an offer down here in Southwest Florida, you're going to have to mark your property, your listing, as pending with contingencies. And as you all know, once you have to do that, it's going to be harder to get showings. It's going to be harder to get those backup offers. You can't simply keep the property active by putting in some language with the buyer saying that you have the right to accept backup offers. It doesn't work that way. Once you're pending, you're pending. It's also kind of complex, and you guys will go over this, but some of these deals are actually pretty sophisticated. They've got multiple addenda, and it's hard to know like all the time frames and when money becomes non-refundable or not. There's just more to it. It's not a simple, easy deal. And anytime something isn't easy, we tend to make mistakes.
Well, and even if it looks easy, it really isn't. I mean, you have a contingency that it's subject to the sale of the buyer's property. That's in writing is simple, but in reality, it's quite complex. Did the buyer make a good faith effort to sell the other property? Did they torpedo the sale of the property in Connecticut or wherever it might happen to be?
Self-sabotaging. So let's look at some of these things that we have to consider. Number one, what's the status of their other property? So once a buyer, even if you don't end up using a sale contingency, it's really important to know what the buyer's motivation is. So number one, we need to know what they're selling. And this is a pretty difficult thing to do. I'll give you a couple examples. Let's say the buyer is from New York, and they're selling a property up in a beautiful subdivision or beautiful neighborhood or town up in New York, and the property is now listed and they have pictures. And how do we know if it's priced correctly? Now we have to do comps in the neighborhood. It's challenging to evaluate whether something is priced correctly in another town, another township. It would be very difficult, but what I do see people do is they'll call that listing agent and they'll talk to them and they'll ask, how many showings have you had and how long have you been on the market? Is this priced correctly, or do you think you'll have something soon or not? And you kind of want to be a little sly about it because you're trying to get honest answers. You don't want the listing agent to be kind of prepped that they're supposed to oversell this, in a sense. Now the trick, there are a couple of tricks to that, right? Sorry, go ahead.
Yeah, it's not just that, Christian. If you don't open your mouth and ask what's going on with the other property, many times you'll find out it's not even listed yet. I mean, I've found that many times. So you got to go digging on the status of the property. I mean, talk to the listing realtor like you just mentioned, but can we see a copy of the contract? Are there contingencies in that contract? How much does that
Yep.
buyer have down on that
Yep.
contract?
Exactly.
A
So,
classic example, you're, I'm sorry, go ahead.
well, I was going to say, we have to look at, is it listed? If not, when will it be listed? Have they already taken pictures? What are they pricing it at? I even had a deal where we recommended putting in that only if the buyer prices it, at or below a certain price point, just so that the buyer couldn't then change it and overprice it and potentially get their money back. But those deals are really tough. The less certainty as to their other property leads to more uncertainty to your property. So sometimes the solution will be just wait. But let's keep going. Are they under contract? Are they past certain contingencies? Past. And so let's look at some pro tips on that. Time of the essence. And Dad, this is one that you and I talk about quite frequently. Well, let's continue to use that New York example. Is time of the essence of closing dates in New York?
No, it's not. In fact, I ran into this with, not to get too personal, your in-laws. Their sale was, their purchase down here was subject to the sale of their property in Long Island. And they were trying to time the sale in Long Island to the closing date down here. And time is not of the essence in New York. And I more or less guaranteed to your mother-in-law that it's not going to close on time. They
That was
never
the
do.
example I was going to use too. In
Sorry
fact,
about
what
that.
had to happen on that deal was, I think the closing date was like July 31st, and come August 15th, it still wasn't closed. And so we reached out to my mother-in-law and we said, hey, did you even ask when they're closing? To kind of prompt them along, let's put them on
Right.
notice, let's get your attorney to reach out to the buyer's attorney and make this happen. And only then did the lender say, oh, okay, sure. Well, let's close in 10 days. So they
Yeah.
were almost a full 30 days delayed, and there was nothing wrong. It was just kind of normal for the
It's
closing date
normal
to
up
come and
there.
go.
Yeah, I mean, that just highlights how different closings are in different states.
Yeah,
Up
yeah. And
there, they
that can
all,
be very challenging when you're trying to line up dates and you're expecting it to be kind of a locked and loaded situation, and they're not.
and your
Other
clients in their second real estate deal of their entire life. They think it's going to close on that day.
Yep, they do that. And even down here, time is of the essence as to closing dates, and we still don't close on time all the time. So it's, things happen. If their buyer has a financing contingency and they need more time for TRID compliance or whatever it may be, they can delay per the contract. So you
Sure.
kind of need to read that New York sales contract and need to match it up with yours. And we're trying to evaluate risks. The other pro tip on this is matching up deposits. So if you've got a sale, let's say you're past all your contingencies on your property up north, and you're making an offer on your property down here in Florida, try and match up the property deposits. So if it's 40,000 down up there, let's do 40,000 or maybe less on the property down here. And that came true just recently. So we had a deal and the buyer decided to walk away. They terminated on their financing contingency, and the seller and them, they're kind of disputing the legitimacy of it. But the real problem, the reason why the seller is very upset, is that they lost their $50,000 deposit and they only had $10,000 deposit on the property they were selling. So they lost 40 grand potentially, maybe more, maybe 50,000, because their deposits weren't matched up. That if the sale falls through, they can't buy it. And now they're really in trouble. And so that's not protecting themselves. It's not a really good risk evaluation in that sense.
Well, I think you told me in Georgia when you were practicing up there, small deposits were the norm. Was that
Yeah,
correct?
absolutely. So when I sold my property in Georgia, I think we got like a 2 or 3% deposit. So on a $800,000 sale, it was, like 20 grand or something like that. Whereas on an $800,000 property down here, I think I had like an $80,000 deposit at risk. So I couldn't necessarily match it up, but I understood that risk. It wasn't something that I was blind to. It seems that in this other scenario, the sellers were pretty naive in that sense. They weren't even thinking to match it up.
Yeah,
So
I really am not a big fan of the contingency where it's subject to the sale of the buyer's property. There's so many layers that you have to analyze to see, what the risk is.
absolutely. Let me see if I can pull up the form. Now we're at this section. Sale of existing property. And we're just going to use the neighbor form. So let's look at it really quick. Let me share my screen. All right, so this is the neighbor form, and a lot of the forms work similar to this one, but you basically you add in relating to the following described real property. So this is the buyer's other property that they're selling. Buyer's obligation under this contract are contingent upon closing of and disbursement on the sale of buyer's real property located at. Maybe this was wrong. So this is the property that you're buying. This is the one that buyer is selling. If such closing and disbursement does not occur on or before, and you put in a date, and we're going to talk about that date, what date you might expect to put in there, then either seller or buyer may terminate, it's optional. Seller's right to terminate this contract shall cease to exist if, prior to exercise the seller's right to terminate, seller receives notice that the buyer has satisfied or waived this contingency. Seller should not be obligated to close on the sale of property fewer than 15 days after the date buyer gives notice to seller of satisfaction or waiver of this contingency. It's a really interesting last sentence there, but let's kind of hit it one thing at a time here. So number one, you got to know the property. You got to do your research on that. Put that property there in that section. And then we got to think about a date. Now, Dad, without prompting you on this, what date would you expect? What would you want in there? And I'll give you the scenario. Buyers making you an offer, 60-day close date because they haven't gotten an offer on their other property just yet. They're trying to give themselves some flexibility. So they say October 15th is our close date and October 15th is our, sale contingency date. Does that make sense? Is that how you might do it?
No, I mean, I tell my sellers they have an out all the way up to closing. I mean, you're off the market and they have an out all the way up to closing. And at the same time, here we are going through hurricane season, you have an obligation to maintain the property. So if there's damage to the property, theoretically, you could be footing the bill for some of that. So it's a very touchy situation for sellers,
Well, and
especially
so I think the
year.
point that I wanted to make is that a lot of people assume that you would put you would match up the closing date. So you would say, if it's October 15th, we're going to put October 15th in this date here so that they're matched up. And I'm going to kind of fight you a little bit on that and give you alternatives. What if we put September 15th? So in that scenario, the closing date is still October 15th, but I'm making this contingency as of September 15th. So let's think about it from the buyer's perspective, and then let's talk about it from the seller's perspective. So buyer's perspective, I'm protected up until September 15th. So it lets me go under contract, list my other property, put down deposits, do inspections, do appraisals, whatever needs to be done. And
Right.
come September 15th, I should have more information. It's, in our scenario, it's a month from now. They have 30 days or so to evaluate this, see if it's going to work, see if a buyer is going to make an offer on their property up north, and then either waive it or negotiate some sort of extension. Come September 15th, the buyer is going to want to make a decision. Do we waive this contingency, or and kind of put up our deposits as that, downside risk? Or do we try and negotiate some sort of extension? Do we go back to the seller and say, hey, we still haven't gotten an offer, we want to move forward with your deal, but we're going to need more time. Can we extend the contingency? So that's how a buyer might look at it. Basically gives them a shot on goal. It lets them go under contract without taking full advantage of a seller potentially. So let's now look at it from the seller's perspective. The seller wants a shorter date. They want less risk, less uncertainty. They want a more sure thing. So if I tell my seller, hey, let's do September 15th. That way, by September 15th, we'll know a lot more, and we'll either terminate the buyer because they haven't waived their contingency and we'll go back on the market. Maybe we get a better offer. Maybe there's a backup offer and we want to terminate this first offer. Because so September 16th, the day after the contingency, seller can terminate this contract unilaterally if the buyer hasn't waived it. I actually really, really like that alternative for a seller because it's a 60-day close. There's a lot of risks. You're off the market for 60 days. Let's shorten up that contingency. Let's make it less. Does that make sense, Dan?
It makes total sense. I mean, they're only tying it up for a month. Now, there are exceptions to that. We have one right now that we're doing where it's a condo on the beach in Marco, and it's the only unit in the building that was for sale. And this seller actually turned down other contingencies from other buyers because she knew she had a very favorable unit, southern exposure, and she just took the risk that somebody would come along and make a full cash offer, which actually happened.
Yeah, and so that's the other alternative, is that you just say no. The seller could always
Just
say
say
no
no.
to a contingency. And so we're looking at different options there. You accept the buyer's contingency of 60 days. Say, all right, if you haven't sold your house in 60 days, then the buyer can terminate, get their deposit back. Or we shorten up the contingency. We say, well, we'll give you 30 days to figure out what you're doing with your other property. And if things move more in the seller's favor, then we're going to make you waive it or terminate. If things move back into the buyer's favor and I haven't gotten any interest and the buyer's shown a lot of good faith, then maybe we extend the contingency. And
Yeah,
then the other one you
and
talked about, Dad, is just no contingency at all. You
none at
basically
all. I mean,
counter.
it really depends upon the property. It really depends upon the parties. If the property, they've been trying to sell it for the last year and they haven't been able to sell it, what do they got to lose? So you're more apt to give them the additional time. You might want to protect yourself against maintenance issues with hurricane season. But if you have, a prime condo like we just discussed, you can just say no. And flipping it around, from the buyer's perspective, what I run into all the time is, buyers will want the contingency added simply because they don't want to own two properties in Florida, not because they need the money financially to buy the other property, but just because they just don't want to own two properties.
Well, then
And
let's talk about that alternative. This is something that I think is interesting. I would say people that want a sale contingency is because they don't want two properties. Maybe that's not the right avenue to take. Wouldn't you agree? Wouldn't you just say, hey, look, I'll put up a ton of money in deposit. Just don't make me close yet, right?
yeah,
Give me the right to extend if I put another 5% deposit down. Give me the right to extend if I pay you for an extension.
I mean, with people like that, I'm more focused on, is it possible for us to get this offer accepted with this contingency? If not, do you need the money from the sale of this other property to buy this? If not, maybe holding that other property might be one of the best investments you got. I mean, looking
Yeah.
at the stock market and everything else going on in the world, if you
Yep.
have a really nice,
And we see that a lot. We see sellers that need more time to get closed. We see buyers that want more time because they've got a rental, and in the meantime, they've got money tied up in a money market account, whatever it may be. But let's
yeah,
talk about the solution that I really like. And again, we're going to go back to like the traditional buyer needs to sell their other property for whatever reason. It may not be completely that they don't have the cash. It could be that the cash is tied up in a retirement account and they don't want to pay
right.
the taxes on it. So if you've got $1 million in a retirement account and you take a distribution, it's going to be a good 20% hit right off the top there potentially. Whereas if you're selling your property and using those proceeds to then buy this one, that tax hit may not exist. So maybe that's the scenario. And so they're just trying to protect themselves and say, well, we don't want to have to pull from the IRA and take a big tax hit. So let's think of other options. So you have your sale contingency. You can already tell just from the way you and I talk about it, Dad, we're not a huge fan of the sale contingency. We don't see it a lot. And anytime someone makes an offer with it, it's like, oh man, this isn't a really great offer. That's kind of the feeling
No,
you get. So
it's
how do
kind of
we
a deal killer because there's
can
so many
be?
things you don't see. There's so much you don't know about the other market. You don't know the other agents. You don't know if you can trust the other agents. And again, you're dealing with people who might have bought or sold two, three properties their whole life.
So let's
Um,
talk about scenarios that we have for alternatives. You're a seller, you receive an offer, it's got a sale contingency, it's that 60 days closing date, 60-day sale contingency, it's subject to financing, it's subject to inspection. There's a lot going on there.
yeah,
What if we just lower the deposit? So on that scenario, let's say it's a $2 million purchase. And I actually had this a couple weeks ago, $2 million purchase. They're offering full price, but with all these sale contingencies. And they're like, look, we'll put 10% down. We'll put $200,000 as our deposit, but we're protecting our deposit by putting all these contingencies, specifically the sale contingency. And so the seller calls me and says, hey, Christian, what should I think of this? I don't know if this is a good deal or is this a bad deal. And I said, well, let me give you some alternatives. And this is the one we came up with. Let's counter and say no sale contingency, but instead of a $200,000 deposit, let's go down to like 30,000. So in that scenario, you've got a low deposit, quote unquote, low deposit, considering the sale price, considering that we're in Southwest Florida, but no sale contingency. So the buyer definitely has skin in the game, but not as much. And so it's just that skin's totally unprotected. It's kind of like, you're wearing a full clothing out in the sun, except for one little area. So if you get burned, you're going to get burned there. So
now
in that scenario, what we were able to negotiate was that $2 million sale price, the 60-day closing date, and a $30,000 deposit, but no sale contingency. And why the seller took that is because they knew that come 60 days, the buyer would either try to renegotiate and try and maybe buy themselves another 30 days, or they would close and we would, it'd be perfect. Or the buyer wouldn't do those things and they'd lose their 30,000. In that scenario, the seller would at least get 30,000. At
Christian,
least.
what do you think of paying the 30,000 directly to the seller rather than in escrow?
Yeah, I mean yeah, I think someone told me you either get your price or your terms. You don't usually get both.
Right,
So it's all about that little dance. So typically, what you and I see is that 30,000 gets put into escrow, but then when the
right,
buyer's trying to negotiate some sort of extension, let's say they need another 2 weeks, you say, all right, I'll give you the extension, but that deposit gets released to me now.
right.
So I don't typically suggest that the deposit be given to the seller up front. That would mean that the deposit's way too low, but it's an option. It's certainly an option.
Well, if I were representing the seller and they're going from 200,000 to 30,000, I would throw that out there, make it payable directly to my client. Of course, you warn the realtor, the listing agent, if you're representing the listing agent, they're entitled to half of that, so you have to bring that up.
Yeah, the
And
downsides with all of this is that it can be hard to convince someone to go this route, right? Let's be honest about it.
it is,
You've got a
it is.
buyer who makes an offer with a sale contingency, and now you're asking them, hey, just put yourself a little bit at risk. Put 30,000 at risk instead of the 200,000, but take away the sale contingency. You'd have to have a pretty astute buyer to kind of make sense of that, I think. And
Well,
like that
yeah.
telephone game, it can get lost in translation as to what the seller's trying to do. So that's a downside. That's always hard to, if you have trouble explaining it, it's going to be hard to win over someone. It's the same thing with a lawsuit. If you can't explain yourself to the judge or a jury, you're going to have a hard time winning, even if you should win. And
Oh,
the other considerations, proof of funds, what do you do then? What I would want is some sort of hybrid. I want to confirm that they don't have any mortgages on their other property, that there aren't any big liens. And then I want to see, what do they have in cash? What do they have available to them? And, the seller just has to be comfortable with that. And then we talked about it a lot already, buyer motivation to close. I do think there are buyers who will deliberately delay a closing on their other property so that they can get out with their deposit on the purchase. We've seen it, where let's say it's on October 30th, closing date, October 30th, sale contingency. They'll purposely accept an offer that doesn't close until November, just so that they can get out of the purchase. And so I don't like those options. And that's why I really lean towards this low deposit alternative if you had to. Because at the end of the day, the seller's taking their property off the market for 60 days. In this scenario, it's August and September, which is not the high time. Maybe you're calculating how many showings you've had recently and what you expect to have over the next 60 days. Maybe you're like, well, we'll wait till the fall or the winter, and then we'll have real interest. So in that scenario, it's, seller takes a property off the market. Maybe they were going to anyways. You get that low $30,000 deposit, but it still covers your bills. It still is a real money. And it doesn't always have to be that big purchase price. I had a deal yesterday, Dad, that was, I think it was a $600,000 purchase price. The buyer had offered $30,000 deposit, so 5%. And I came back and said, well, what if you just take 7,000? That was the number that ended up making sense to the seller. Take 7,000, you're off the market for about 2 months. And if it doesn't work, that covers your costs over the last 2 months. And like in that scenario, Dad, you could negotiate that maybe the deposit gets released to the seller automatically, something like that.
Yeah, I think anytime you go that low, I mean, people don't realize that there's always escrow disputes. If a deal falls apart, no matter what the contract says, the buyer's not happy, the seller's not happy, and getting both parties to sign a release of that $7,000 deposit to the seller is difficult.
Yeah.
They're upset, they're emotional. So if you can get it up front, I mean, it's really not that much different than getting it down the line when they're negotiating an extension, getting part of it released.
Yeah. Yeah. And in fact, Christina asks on the question, she goes, what if you split it up and did 50% in escrow and 50% to the seller? You could do 100%, you could do 50, whatever you negotiate. And like you said, Dad, you're trying to prevent a buyer from leveraging that deposit against you later. If the money's already in the seller's account, it's harder for the buyer to get it back, much harder.
Well, and the hard cold reality, if you have a small deposit, $10,000-$20,000, the cost of hiring a lawyer and filing a interpleader action and fighting over the money is not really cost efficient. I always use playing poker in Las Vegas as a metaphor. If you're fighting over a $10,000 deposit, would you, if you were in Las Vegas, pay $5,000 plus the other side's attorney's fees to win, the 10,000 or whatever small amount we're arguing over?
Well, and there's a follow-up to the question, and she said, I was thinking more about protecting the agent a little bit in that scenario. If 50% of the deposit's still in escrow, that actually makes sense because the listing agreements give the listing agent the option to retain 50% of the deposit in the event of a buyer default. So that's actually pretty sophisticated. Definitely something to consider. I
think the agents have to bring that up relatively early, because there's case law out there. You can't sit on it and then 6 months later say, hey, you owe me half.
So personally, I wouldn't want the seller to hold the deposit up front for one reason, is it takes a tool away from you to use later. So we talk a lot about trying to keep people in a deal. And if the deposit's already been released to the seller, all of a sudden you've lost a lot of ability to negotiate something. There's nothing for the seller to win anymore other than more of a deposit. So I like to keep that in my back pocket. I want the deposit to be held by the escrow company because that's what we normally do. And then if we need an extension, we have that. It's an easy one. We got another question. Can you do a 60-day contingency for buyer to sell their home, but do an addendum to keep the home active on MLS and give the buyer first right of refusal? So that's kind of like a kick-out clause. Couple of things. Number one, I don't think there's a way for you to keep the property active. MLS rules say that once you went under contract, you have to list it pending. In this case, it'd be pending with contingencies. you're just going to have a hard time getting people to show up to your property. So unless MLS changes that rule or there's some other option for you, I don't think that works as well. It doesn't matter what the buyer and seller agree to. These are your MLS rules that are going to make you do it a certain way. But there are kick-out clauses. You can, whether the buyer agrees to it or not, you can accept backup offers. And you can put kick-out clauses in your primary offers. You can do that where it says, if you get an offer, the seller can, make the buyer come up and waive contingencies. There's those forms are available. That makes sense?
It makes sense.
Maybe.
Maybe.
These are good questions. I really appreciate it, guys. We won't take you too long anymore. Good luck with these. They're complex, but it's really kind of important to think about the strategy, preserving options for the future. I did see one recently where the seller had the right to terminate the contract in the event the buyer wasn't under contract on their other property within a certain time frame. Probably no different than just a shortened financing or a sale contingency. But the other thing, I'll leave you on this one. If a buyer is denied for a loan because they didn't sell their other property, that's only a valid denial if you had a sale contingency as part of the contract. It does not protect a buyer under just the standard financing contingency. So keep that in mind. If you have questions about that, don't hesitate to reach out. Good luck, everybody.